Hello students, welcome back to studies. In this video, we will discuss the classification of contracts. Contracts can be classified on the basis of formation, on the basis of validity, and on the basis of performance. On the basis of formation, contracts can either be an express contract, it can be an implied contract, or it can be a quasi contract. Now, what is an express contract? If the terms of the contract is expressly stated either orally or in writing, then we call the contract as an express contract. So if the offer or acceptance of the promise is made either in words written or orally, then we say that the promise is said is express promise. So express promise leads to express contracts. Coming to implied contract, an implied contract is a contract which is implied by the acts of the party, the way in which the parties act, or by the conduct of the parties, or by the behavior of the parties. In this case, the contract is not formed expressly either by oral or writing. It is implied by the act or conduct or behavior of the parties. So this is an example for implied contract. Now, Upton Fire Brigade it is a fire brigade service and it had two types of service zones. One is pre-service zone, okay, and then the paid service zone. Now, a fire broke out in Peace Farm and he immediately called the Upton Fire Brigade to put out the fire. Upton Fire Brigade went ahead and put out the fire, but P was under the impression that it was a free zone and he did not have to pay for the service of Upton Fire Brigade. But in fact, uh, Peace Farm did not come under the free zone of Upton Fire Brigade. As such, he was supposed to pay. Okay, so Peace Farm did not come under the free service zone, although he believed so. Held, he was liable to pay for the service rendered, as the service was rendered on an implied promise to pay. So that was to say, even though he is under a false impression that his farm comes under the free zone, he is entitled to pay for the services of Upton Fire Brigade because there is an implied contract. Other simple examples for implied contracts are when you are boarding a public bus, it's an implied contract that the bus will take you from destination A to destination B, for which you'll have to pay the bus fare. Likewise, when you go to a restaurant and order a cup of coffee, there is an implied contract that uh, the restaurant will serve you the cup of coffee, and then you have to pay for the cup of coffee. All these are examples for implied contract. Next, coming to quasi contract. Strictly speaking, quasi contract is not a contract at all. Taking the second example over here, T, a tradesman, leaves goods at C's house by mistake, and what C does is he treats the goods as his own and he uses the goods. Okay, in this case, C is bound to pay for the goods because it is not belonging to him, it belongs to T. There was no contract as such, but then C has utilized the goods, has used the goods. As such, he is required to pay for the goods. The two parties in this case are T and C, but between them there is no intention to create a contract. Okay. Now, such type of contracts wherein the parties do not intend to enter into a contract but are bound by an obligation, in such cases it is called as a quasi contract. Next, coming to the classification of contracts on the basis of validity. On the basis of validity, a contract can either be a valid contract, void agreement, voidable contract, illegal agreement, and unenforceable contract. A valid contract is a contract which is enforceable in the court of law. Now, when is it enforceable in the court of law? It is enforceable in the court of law if it meets all the essential elements of a valid contract. So, what are the essential elements of a valid contract? There should be a valid offer, there should be valid acceptance, there should be an intention to create legal relationship between the parties. The parties to the contract should be competent to enter into contracts. There should be free consent. That means to say acceptance has to be given by free will. There should be a lawful consideration. The object of the contract has to be lawful. Any of these agreements should not be opposed to public policy. If there are any legal formalities that has to be taken care of, all those things have to be taken care of. In that case, we call the contract as a valid contract. Now, in case if any of these essential elements of a valid contract is missing, any one of the essential element of a valid contract is missing, then we call the contract as a void contract. So, void contracts are those contracts which are not enforceable in the court of law. These are unenforceable contracts. But we need to keep in mind that void contracts, when it was in the formation state, when the contract was formed, these contracts were absolutely valid contracts, but later on it turns out to be void. In case while entering into a contract itself, if it is not enforceable, then we call it as a void agreement. Take for example, if an agreement is entered into with a minor, it is void agreement. It is void at the beginning itself. So we talk in terms of void ab initio. Void ab initio is void at the beginning itself. As such, you don't call it as void contract. But when we talk about void contract, initially when the contract was formed, it was perfectly enforceable, it was perfectly valid, but later on it turns out to be a void contract. For example, if one of the parties becomes insane, during the formation of the contract, both the parties were competent to enter into contract, but on a later date, one of the parties become insane. In such case, you call the contract as a void contract, okay, because it is not enforceable in the court of law because one of the parties has lost his competency to enter into contract. Then comes voidable contract. Now, voidable contract are those contracts where one of the party has the option of treating the contract as either a valid contract or he can treat the contract as a void contract. Take for example, A promises to sell his mansion to B for rupees 2 crores. His consent is obtained by use of force. That is, A does not on his own wish to sell his mansion, but he is forced to sell his mansion to B. Now, in this case, the contract is voidable. Okay, so A has two options. Either he can treat the contract as a valid contract and go ahead with the contract, or he can treat the contract as a void contract and he can go to the court of law asking for, asking the court to set aside this contract on the basis of no free consent. Now, this option is available only to A. That means to say, there is no option for B to consider this contract either as valid or void, okay, because he has forced A to give his promise. As such, it is voidable only at the option of A. Such type of contracts are called as voidable contracts. Next, coming to illegal agreements. Illegal agreements are those agreements which goes against the law. In case if it is criminal in nature, in case if it is immoral in nature, or in case if it is opposed to some public policy, in such cases, we call the agreement as an illegal agreement. Okay. Let us take this example. B borrows rupees 50,000 from A and enters into a contract with a condition to import prohibited goods. So let us say B enters into a contract with C for purchase of prohibited goods. And the amount that he requires for purchasing this prohibited goods is rupees 50,000, which he does not have. As such, he goes to A and borrows the money from A. A already knows the reason behind B borrowing this money. He knows that B is borrowing this money to purchase the prohibited goods. In this case, this contract, the first contract between B and C is anyways illegal, but the collateral transactions, that is the second transaction between, which is collateral, which is, I mean, the B contract between B and C is a main contract, and the contract between A and B is a collateral transaction. This collateral transaction also gets tainted with illegality. So the first agreement is anyways illegal, that is between B and C. The second agreement which B undertakes with A is also tainted with illegality since A knows the reason for B borrowing the money. Okay, so A knows of the purpose of the loan. The transaction between B and A is collateral to the main agreement, and as such, the loan agreement is an illegal agreement. Now, coming to unenforceable contract. Unenforceable contracts are those contracts which cannot be enforced in the court of law because of some technical defect in the contract itself. So, because of some technical defect, the contract is not enforceable in the court of law. Take for example, if the signature on the document is missing, or in case if the contract has to be on a stamp paper but it is not on a stamp paper, in case if it has to be, if the document has to be registered and if it is not registered, all these are technical defects which render the contracts as unenforceable. It cannot be enforced in the court of law because of such technical defects. Moving ahead, on the basis of performance, the contract can either be an executed contract or it can be an executory contract. Now, an executed contract is a past contract. The parties to the contract have already performed their part of the obligations. Whereas, in case of an executory contract, it is futuristic in nature. That is, either one of the parties have already done his part of the job and only the other party is yet to perform, or in case both the parties are yet to perform their part of the obligation. In such cases, you call the contract as an executory contract. For example, A agrees to paint a picture of B for rupees 10,000. This is the contract between the parties. A paints the picture and B pays the price. So both of them have already done their part of the respective obligations. As such, it is an executed contract. Whereas in the second scenario, B has paid the money to A for painting the picture, but A is yet to paint the picture. In this case, the contract is called as an executory contract. Or in case if B has not paid the price and A has not yet painted the picture, but they will do it on a later date. In such cases also it is called as an executory contract. The same classification can be looked into as unilateral contract or bilateral contract. In case of unilateral contract, one of the parties have performed their part of the obligation and another party is yet to perform. So in case if B has already paid the price for painting the picture, but A is yet to paint the picture, in such cases you call it as a unilateral contract or contracts with executed consideration. One of them has paid the consideration, the other person is yet to perform his part of the obligations. In such case, you call it as a unilateral contract. In case of bilateral contract, both the parties are yet to perform their part of the obligation. So the obligations of both the parties are outstanding. For example, A permits a railway coolie to carry his baggage and place it in a carriage. A contract comes into existence as soon as the luggage is placed in the carriage, but by the time the luggage is already placed, the coolie has already performed his part of the obligation. So only one part of the obligation is now remaining, that is A has to pay the reasonable charges to the coolie. In this case, you call the contract as either an unilateral contract or you call it as an executory contract. That's all for now, students. Hope you all had a pleasant learning experience. See you all in the next video. Thank you.